Yeah. Yeah, what are you trying to do with a motion? Who's drafted a motion? Good. Give me an example of a motion that you drafted. Somebody that had your hand. Yeah.
A motion to clarify arbitration award.
Motion to clarify arbitration award. You drafted that? Good job. And what were you trying to get the court to do? And I assume it was drafted at the court, or was it drafted to an arbitrator?
It was drafted to the court to pretty much, because the employer in the case was refusing to pay back the back pay wages because they said the arbitrator didn't have jurisdiction anymore, so we had to pretty much go through the courts to get it remanded back to the arbitrator to have him have the exact number computed and everything.
Right. We're asking for something very specific. We're not trying to start a new case. We're not trying to dispose of a case. We're not answering allegations against me. I want this one thing to happen in the context of the overall case. That's a motion. Okay? Less comprehensive, as you have already said. Then a plea. Another example of a motion. Who else has filed a motion? Yes, sir.
Motion for preliminary injunction.
Motion for preliminary injunction. Yeah. And what's a preliminary injunction?
Well, they're asking the court to prevent defendant from having no business litigation to.
Yeah. So you're saying, defendant, stop doing the thing that you're doing. Court, order the defendant to stop doing the thing they're doing. Okay. But that's in the context of an overall suit. You file the pleadings, the suit has happened, the action has happened, it's already in full swing. Then you file your motion for preliminary injunction or your motion for whatever it is. And as you know, if you've been in my class and done a little bit of this motion practice, those motions can be pretty much for whatever you want. Okay? Not so with pleadings. With pleadings, we have certain parameters that we have to obey. What are those parameters? Well, that's why you're here. We'll talk about it the rest of the class and on Friday. But what is the very first thing that gets filed in a federal civil case? Who knows? What's the first thing? Yeah. Complaint? Who else says complaint? Complaint? Anything else? Wrong. You're totally wrong. It's a trick question. See? Actually, the first thing, hey, you're right. You're basically right. But what goes along with it is, yes, go ahead. This civil cover sheet, right? Accept the license every single time. Here we go. This civil cover sheet, right? In the federal courts. Now, is it annoyingly different in every single court that you're going to practice it? Yes. Yes. It's mostly uniform in the federal system. Okay? Mostly uniform in the federal system. But in the state courts, anything goes. You got one of these that you file in the state court? No, not really. You just file your complaints, your summonses, which we'll talk about too. And that's it. But to initiate a civil case in the federal court, you got this simple one-pager that you can easily Google and get from the court's website. The civil cover sheet. Okay? And technology is such, in the federal system, not the state system yet, the technology is such that you can actually fill out these forms online. Right? I think. There's fields there that you can fill out. Basis of jurisdiction. You have to know who the plaintiffs are, you have to know the defendants, you have to know the county of residence of each one of these. Okay? Attorneys, basis of jurisdiction, and this is where you get into last semester stuff. Right? Federal question jurisdiction, everybody knows what that is, right? Yeah, good. Diversity jurisdiction. Okay. Then they ask for the citizenship of principal parties. Principal is AL. Remember that, very important. And why do we need to know the citizenship of the principal parties? Yes?
Because it helps with diversity jurisdiction.
Yeah, you have to determine whether or not there really is complete diversity between the parties. And remember, there has to be complete diversity between the parties to obtain diversity jurisdiction. You all remember that, right? You just have to warm that up a little bit. Diversity jurisdiction is a thing that you'll deal with in practice. At least in my experience. You go to regular civil practice, you will deal in some way with diversity jurisdiction. If you don't know anything about diversity jurisdiction, and you're just trying to blunder through a civil practice, it can be problematic. With diversity jurisdiction, that gives you the ability to get in or stay out of courts that you might want to be in or out of, if that makes sense. And that can be very powerful and very good for your client, as we will see in the next 80 to 90 slides. Okay? That's a civil question. But then you file a complaint. We've already said, what does the complaint say? What did it say to? And you're saying to, the plaintiff is saying to the defendant, here's all the stuff that you did wrong, and here's what you owe me. Okay? Simple as that. But how do you know what to put in there? How do you know? How would you go about drafting a complaint? You go out and hang a shingle. You started this new law firm. You're very excited. You just couldn't get a job after law school, and so you're just like, I'm just going to hang a shingle and do a civil law practice because why not? I know really dumb people who do it. And a client comes to you and says, I've been wronged. I have been aggrieved, and I demand a recompense. And so you have to draft a complaint to get that into court on behalf of your client. How do you go about doing it? Well, yeah, go ahead.
Well,
There's a rhetorical question, but I mean, you have to answer, right?
Well, first of all, you need to know the main fact about what happened. What exactly was the, is he saying was the wrong?
Yes. Yeah. Yeah, it would be good to have some factual information in that complaint. We'll get it. All right. But it can be kind of a daunting and intimidating exercise. Oh, I represent the person, I'm going to draft this complaint. Now I know all right stuff. So let's talk about that. First, federal rule number 10. Federal rule number 10. Not very helpful. But it does give you the form of pleadings. It's like you flip through, many lawyers that have been in practice for a long time don't do this. Right? But flip through the rules and look at the title of the rules. And sometimes that's very helpful. So if you come across a rule in the form of pleadings and you're trying to figure out what the form of your pleading should be, there's some help there. Yes? I don't know. Is that not one? Yeah, that's tiny print, sorry. Oh. Did it work?
Yeah, it's right. Oh, it's okay.
Yeah, okay, good. But anyway, all this is the textbook 10. Okay, so if you can't see it, just look. But it tells you that you got to put the names of the parties. Okay, that makes sense. Paragraphs, separate statements. If you've ever looked at a complaint before, you know you have 1, 2, 3, 4, 5, 6, 7, right? Numbered paragraphs that say different things. The formatting of the thing isn't so much the issue, it's the content, right? But know that you've got to have numbered paragraphs. So when you get down to drafting a complaint, which will be very soon, hint, hint, right? Know that that's at least something you got to have there. The names of the parties and your numbered paragraphs. It's by reference exhibits, but we won't be doing any of that. You can. It's oftentimes not necessary, but you can include exhibits with your complaint or with your plea. Most of the time, not necessary. But who's a potential third audience that you're writing to? If you're the plaintiff, put your plaintiff's hat on for a minute. But think about this. You file a complaint. It goes to the judge. It goes to the defendants. And who else has access to it? In most cases. Sorry? Thought I heard it. The public. Yeah, the public has access to it. So if you think you're filing something that is of public interest, and trust me, you never know when you're going to end up on the news with your client, then might you want to attach more stuff to your complaint? Might you want to attach more proof that things are the way that your plaintiff says they are? Maybe. Maybe. This just says you can do it. But this is very rudimentary, very basic stuff. It doesn't really tell you a whole lot about how to draft a complaint that way. So, Federal Rule 8. Huh? That's a little more helpful. But not great. Not great. Right? Pleading the state's a claim for relief. What does a claim for relief mean in this context? Yeah. Give me an example of a claim for relief. What does that mean in this rule? What does it mean to say that I'm making a claim for relief, right? The court.
Saying that the defendant has to pay.
Yeah. These are the facts in the law that entitle me to relief and entitle me to compensation or entitle me to something from the defendant, right? Sometimes, as in Seth's example, you're asking that the defendant change their behavior in some way. Stop doing a thing, right? Or do something else. Most of the time in civil litigation, a claim for relief is saying, here is the law, here are the facts that entitle me to get money from this defendant. Right? Everybody gets that, right? So a short and plain statement, a claim showing that the pleader is entitled to relief. Well, what could be more simple than that? A short and plain statement. Great. So all my complaints can just be one pagers, short and plain, very simple, bare bones, little statements saying, I am entitled to relief. I am entitled to this defendant paying me some money. We're doing something different. We're doing something. And those of you that have done the reading, is it that simple? No. Oh, of course not. Or you wouldn't get paid $300 an hour. Right? Short, plain statements of a claim showing the pleader is entitled to relief and demand for relief. Sorry. What is a demand for relief? What is a demand for relief? Yeah. That's what you're asking for from the defendant, basically. Yeah, but yes, you're right. You're asking the court to order the defendant to do a thing. Pay you money or do something. It's usually pay you money, right? That's your demand for relief. We'll look at examples of all this stuff. Have no fear. Have a little fear. And what is relief in the alternative that we see there in paragraph 3? The demand for relief, which may include relief in the alternative. Yes?
If the court doesn't think that the original type of relief sought is viable, then there's a kind of second option.
I think you've got it, yes. So if you're the plaintiff, and you're pleading, you're asking for relief in the alternative. Right? This is within your province. Remember, this is a rule directed to you, the plaintiff's attorney. How do you ask for something in the alternative? Somebody give me an example of that? Relief in the alternative? Yeah.
Like if you're doing like women's court motions or something, you're going to like your main argument and you're like in the alternative without waiting enough time for your argument. Even if you don't agree with that, you should give your argument this.
Okay. You've drafted dispositive motions or responses, right? Yeah. You can tell. They just have that sort of war zone look. I've really been through it with these dispositive motions. Yeah. So for example, when you're asking for relief in the alternative, A, D, and E speaks to these two. Right? Wait, I'll come back. A, B, and C, just real quick, we don't care about in the context of talking about complaints and why. You know this because you read the rules. You memorize them. I didn't memorize them. But B and C, what do B and C do? They're for the other team, right? They deal with the answer, okay? They deal with responses to the initial pleading. The responses to the complaint, the answers. So we're not worried about those yet. D and E. Again, we have this reiteration of pleading needs to be concise and direct. Yeah, kind of, right? If you read A, Paul, you know that there's an asterisk about that. Alternative statements of claim or defense. Okay. Well, first, paragraph 1, no technical form is required. Again, we'll get to A, Paul. It's kind of true and kind of not true. Alternatively or hypothetically. You may make your claims alternatively or hypothetically. Right? What does that mean? Separate claims or defenses may be made regardless of consistency. What is that? Well, think about the difference between intentional torts and negligent torts. You draft a claim for battery, okay? Saying this person intentionally ran me over with their car. Okay? That's battery. That's an intentional tort. Okay? If you were to plead that case in the alternative, what would your alternative claim be? You don't want a complaint out there that's just battery. You don't want a claim out there that just hinges on that intentional tort being made. What else do you want in that complaint? Negligence. Is it possible to have acted intentionally and negligently at the same time? No. Right? You can't do that. But you're saying you can make both claims in the context of a complaint? Yes. That's what this rule allows you to do. You should do it. You're drafting a complaint, you should do that. You should lob everything out there that you can possibly lob because you don't know what's going to survive by the end of your case, which could be very short. And what's not going to, right? Would it be possible, and I'm jumping way ahead here, would it be possible for me to file a complaint for battery in that context, and then battery only, and then I get hit the next day with a motion for summary judgment that says clearly this wasn't intentional? Is it possible for the defendant to file something like that? Sure, it's possible. Sure. Do people file dumb shit like that all the time? Yes. Okay. But that's an example of alternative. By the way, I don't know if you covered this last semester, but every state has its own little pet version of all these rules. Right? So we're talking about the federal rules mostly in here, but I'm going to refer to those Kentucky rules every now and then because guess what? Many of you will go to a state practice, or you won't touch the federal courts ever in your lives. And be thankful for that. But what is the counterpart in the Kentucky civil rules of this one? to Federal Rule 8A. Yes?
Similar 8.0.
That's what it is. You need to look it up in Westlaw. That's what you get. NYCR 8.01. Okay. Bonus rounds, if you cite this in Kentucky courts, just cite CR 8. Okay. That's how it's like. Pretty soon example. Right. If you look at, actually, let's pull it up. Here's some. Let's pull that. Westlaw. We're watching it come up. CR 8.1. And then in the last, I think you guys scroll down here. You get some cases. If you go to statutes and court rules, this is the court rules. CR 8.01, there it is. Is this, my question is simply this, and I'll move on. Is this the same thing as Federal Rule 8A? It's a simple question. Well, is it the same as 8A or not? Pretty close. Really? Not sure. Yes?
Yes.
In essence, right, this thing here is the same, but then you got this thing down here. It's still part of CR 8.01. It talks about what you can do in terms of liquidated and unliquidated damages in your complaint. Does anybody have any idea? Remember from contracts, if you're covering contracts, the idea of liquidated damages, unliquidated damages? Okay, that's what this speaks to. And the thing to remember is that in Kentucky courts, you don't put the amount that you're seeking from the defendant into your complaint. Okay? That's the thing, that's the basic rule. In federal courts, you can't. You don't have to. All right. So if these rules aren't super helpful, how do you know how to draft a complaint? Well, there's case law, I suppose, that interprets those rules, which we'll get to. But here, for your reference, in case you ever need it, before the end of the week, let's say, here's the anatomy of a typical complaint. Style or heading, drafting a complaint, you probably know about all this stuff already. Names of the parties, the file number, all that stuff. Okay? You don't put the right case number on your complaint, so you can't put a case number on a complaint. If you don't put the right case number on a pleading, or an answer, that's a problem. But when you draft a complaint, you're not going to have the actual case number on there because in most cases you don't have a case number. So you leave that blank and the clerk fills it in. You do have the names of the parties filtered. Sometimes you don't even have that. You have unknown defendant. That's also a possibility. And that's 2.0 draft. We'll talk about it. Introduction. Many examples that you look at, many complaint examples that you look at will not have an introduction or a preliminary statement. Fine. As we've seen, the rules don't require it. But good practice, which you don't know until you've been in practice for a while, good practice dictates that you put something in there to let the court know this is this type of action. This is an action for battery. This is a civil rights action. This is a petition for dissolution of marriage. Okay? Tell the court what it's about. Description of parties, self-explanatory. Statement of jurisdiction. I maintain that in just about every document you ever file with the court ever, you need to reassure them that they have jurisdiction to do what you're asking them to do. Okay? That's especially true of initial pleas. Okay? What is the authority under which you are able to get this thing into the court in the first place? Is it statutory authority? Is it common law? What allows you to do that? Here's a fun thing. Think ahead to 8 Ball. Read the 8 Ball case, right? Of course, it's still early in the semester. Everybody read 8 Ball. And 8 Ball is what kind of action? Does anybody know? It doesn't really say in your reading. It's excellent. Yes.
Is it civil rights?
It's a civil rights action. How do they get it to the court?
By constitutional.
Well, it's a constitutional issue. But don't go thinking, the reason why I bring this up is, you always go plaintiff's practice. You have an aggrieved plaintiff that comes into your office, says, everybody wants you to file a complaint. I think my constitutional rights have been violated. You don't get to just file a complaint that says their constitutional rights have been violated. You have to have a vehicle to get that case into court in the first place. The Constitution itself says nothing about you get to maintain an action in the courts, in Article 3 courts, for violations of this document. Right? You don't get to do that. You have to have some kind of statutory authority or other authority to get there. The way they get there in the 8 Ball case is a curious thing, which to really learn about that, you have to take my rights course. But anyway, telling the court what your vehicle is for getting there, that's part of your statement of jurisdiction. It's not just, this is based on diversity jurisdiction, or this is a federal question today, or this is a maritime action. It's, here's the vehicle and I'm bringing these claims through. If it's the common law, fine. It essentially is an 8 Ball. Right? Facts, statement, facts. Claims, you usually have those separated out from your facts, although you will see all kinds of different things in practice. But usually there's a big section about here are the facts, and then there's usually a section that says count 1, battery, count 2, negligence, count 3, intentional infliction of emotional distress. Something like that. Those are your claims. Prayer for relief, what is a prayer for relief?
What you're asking for.
Court, make the defendant do this. Good luck. Give me money, make the defendant stop doing the thing. Right? Give me a jury trial. That's your jury name. Signature block, important. You leave that off, it's a violation of Rule 11. Verification. Did you guys cover any Rule 11 last semester? Anybody? Yes? Good. You can get most of that in your ethics class. But that's a big part of Rule 11 too. You gotta sign all your stuff. All your motions, all your pleadings, all your everything, you gotta sign. And the verification form, what's a verification form? You don't have to have this. But again, much of this stuff you don't have to have. You read the rules. So technically in the rules, you don't have to have an introduction. You don't have to have much of this stuff. What's a verification? Has anybody ever done one of those? Yeah.
Is your verification form like, does it have to be notarized?
Yes, it's basically a notarized signature that you append to the end of the complaint that basically makes the complaint have the effect of being your client's testimony, sworn testimony. Does that make sense? And why would you do that?
Because it's basically swearing that all the facts that they're given are true and all that they're claiming happens true.
Yes, and remember, this is your client, okay? You're representing the plaintiff, this is your client saying, okay, all the stuff, I've read over all this stuff, and all the facts that are in there, I swear all those facts are true. Okay? Why would you do that as a plaintiff's attorney? Do plaintiffs sometimes lie to you? You'll find out. But you need to protect your own license, right? First thing is that license, protect your license. Right? And verification forms are a good way to do that. Let's look at some examples. Your textbook on page 334 has a pretty good example. One of these things I would like. There you go. Heading, the names of the parties, the civil action number, which I don't know how you get that. When you first file a complaint, but that's okay. Complaint, it's nice and neat, right? Everybody see that on 334? Parties. 1. Plaintiff. 2. Defendant. Jurisdiction. 3. Subject matter jurisdiction pursuant to 1338 and 1367. And why? It's not just a simple statement that this is good practice, not necessary practice. It's good practice. You quoted your jurisdiction statute. You also say first and second claims arise under a federal statute. And since those claims arise under a federal statute, you have federal question jurisdiction, right? Makes sense? Your claim for relief arises under state law. Supplemental jurisdiction. You guys did supplemental jurisdiction too, right? If there's any of this you feel totally lost on talking about class. Factual background. Again, 1 fact per paragraph. We'll talk about why that's important soon. First claim for relief, copyright infringement. Second claim for relief, violation of attribution. I've never filed something like this ever in my life, but conversion. That sounds a little more familiar. So here are your 2 federal counts. Here's a common law state claim. The court gets to exercise supplemental jurisdiction. Signature block, demand for jury trial. Like, and your book has a note about this. I've never seen it in my life, I don't think. It's not common practice in the country in Indiana that I'm aware of to have 2 separate signature blocks. Just a curiosity. Most all complaints I've ever seen have just the 1 signature block at the end. It doesn't matter. You want to sign it twice? Go ahead. Sign it twice.
Well, didn't the book say because the jury demand was used?
Yeah, no, I mean, I get it. I get what the rationale is for it, but I'm just telling you, I don't see it in practice. A couple more, one from Ohio. Right, again, preliminary statement, same thing as introduction. Gives you, sorry, you didn't have to do this one. This is all that, the heading tells you where the court, what court you're filing in. Case number is blank, of course, because they don't know what case number is yet, just filing a complaint. All this gobbledygook is specific to civil rights cases. Really, it just needs defendant name and address for service process. Also, preliminary statement, parties. Who are they? What are they doing here? What's their role in this whole thing? Statement of facts. Okay? Lots and lots of facts. Why do we have lots and lots of facts? Because of Twombly and Iqbal. Okay? But also because complaints like this are often a matter of public consumption. Again, you may not just be speaking to the judge and the defendant in these complaints, and you never know who's going to pick it up and say, here's what the plaintiff is alleging in this case. First cause of action, excessive. 1 simple little paragraph. Would I draft it that way? Maybe, maybe not. But you can see that they're clearly broken out by claim, right? Makes me a little uncomfortable having only 1 paragraph on each one of those, but that's okay. Jury demand, plaintiff request jury trial, all claims trial, jury. Simple as that. Right? Prayer for relief, compensatory damages, punitive damages, costs, prejudgment interest, such other and further relief. No. And then there's your signature block. Okay. Compensatory damages and punitive damages, we don't know what that stuff is yet, or whether you should be. I imagine you probably know what it is by now, just after reports. But if you are not sure whether and how to include this in the pleading, we'll get there. Basically, what I can tell you is the simplest thing to do is to put it all in there if you're not sure. Okay? Put it all in there if you're not sure. When you're drafting a complaint, it's better to draft too much than too little, because the defendant will tell you if you're wrong, and sometimes they'll tell you you're wrong even if you're not wrong. Okay? But compensatory damages is something you typically ask for. In most cases, you'll be asking for punitive damages as well. Okay? Doesn't mean you get it. Attorney's fees, also something very common to ask for. Costs, etc., etc. Okay? Questions about any of that? No? That's the anatomy of a typical complaint. Let's skip over the other one. We got maybe on Friday. So that's the questions. The first one talks about merging the 2 separate documents into one, the jury demand along with the complaint. And it says here too that this is your option as a plaintiff's attorney, to ask for a jury trial or not. Who think a reason why you might not want a jury trial? Those who ever not ask for one. Yes.
If your plaintiff is not a good, like they're not a good person.
Yeah.
Not
They're not good for
yeah.
Then you should decline representation. But sometimes you can do that. Yes.
Actually, kind of thinking that off, if they already have if what they do somehow has a bad name within the community already, then they might not see a favorable light by the jury already.
Right. You're worried about the jury being prejudiced against your client. That's one reason. Yeah. Anything else? Yes, James.
You're seeking only equitable relief.
Yeah. You would not. If you're getting relief as a matter of law, and that's not something that a jury can award. You don't need to go down the rabbit hole. Anything else? Yeah.
If it's highly technical, like specifically I'm thinking about patent litigation, sometimes getting that across to the jury.
Getting it across to me? I totally own that. But yeah, I think that's right. If you think it's going to be too complex for a jury to really get, but you guys are missing a big one. That's a big reason why you would opt for a bench trial as opposed to a jury trial. Yes.
Time.
No, time and money. That's a good one too. Yeah, time and money. It takes a lot longer to try a case in front of a jury than it does in front of a judge. Put it this way: why might you want a jury instead of the judge? Yeah.
Better chance to get a majority in some cases.
Yeah, better chance to get a majority. Better chance to what?
You could win a better jury settlement.
You can win a bigger verdict. You can get a bigger verdict out of a jury than out of the judge potentially. But all that comes down to what? Know thy judge, right? Know thy judge. So the biggest reason that you might want a bench trial instead of a jury trial is because you think you can get a better deal out of this judge. Okay? So if you have a judge that you're pretty sure is going to be predisposed to rule in your favor, and sometimes you know, and sometimes you don't know. You don't know, well, better off go to jury, right? Which is always a spin on your left. But you got to know something about the judge that you're practicing in front of. And that's not important just for bench trials and jury trial distinctions, but also for the Iqbal stuff that we'll talk about. Okay. And sometimes you'll see also these in-rate proceedings. habeas corpus actions, bankruptcy actions, certain domestic relations names, what else have I got on here, land proceedings, right? In re Galt habeas corpus case, in re annexation of 466 acres of land is an example of a real case name, it's goofy sounding, but you may have seen something like that in property classes. In re Washington Mutual property bankruptcy, right? You can sort of infer what these are based on the news. So you see that stuff. Sometimes you'll have to draft a petition like that. Okay, Rule 10 says that the paragraphs in the complaint have to be numbered. And you want to keep those allegations in each paragraph as discreet as possible, right? You want to keep them as limited as possible. Why? Why not just say, paragraph 1, plaintiff was struck by a car heading north, driven by defendant with a passenger named Jake, and I should get money. Okay. Why not? Why not just do it like that? Good drafting? Okay. You barely read it. Why not? I submit to you, you want to break this up as small as you can possibly do. Plaintiff was struck by a car. Okay? The car was heading north. The car was driven by Jake. Or no, passenger Jake. Sorry, I don't even know my case. Passenger Jake. Right? I should get money. Break all that stuff up. Something like that, 5, 6, 7 paragraphs. Why? What happens after you file a complaint? What's your plaintiff's attorney have? What happens after you file a complaint? Worry.
I know, like, at least in the answer whenever they deny like certain facts in these features, know exactly what you're going to speak on.
That's exactly right. That's exactly right. If I'm the defendant, I have to answer something like this. I'm going to say, defendant does not have sufficient information to confirm or deny all of these insane allegations. Therefore, they're denied. Right? And that's all you get. But if you break them up in the answer, you might see plaintiff was struck by a car. Admit. Heading north. Admit. Driven by defendant. Admit. With a passenger named Jake. Deny. I should get money. Deny. Right? So you can start to break down what you agree on and what you don't agree on. As a plaintiff's attorney, sometimes there's little nuggets of joy lurking in what they admit to. Okay? Incorporating earlier statements by reference. Okay, look back at your complaint on 334, and you'll see, look under first claim for relief. You see where I am? Plaintiff readopts and redevelops everything. Look under your first claim. Under everything. Plaintiff readopts and redevelops the allegations set out in paragraphs 1 to 12 of this complaint. Do you have to do that under the rules? No, but you should. Okay, you should. Why? Because you, I mean, as a plaintiff's attorney, you never know what you're going to get dispositive motions over. You get lots of them all the time. And if you ever get somebody coming and saying that this claim doesn't adequately tie the facts to the law, you can say, but judge, I reincorporated all the allegations I made above into this claim. Okay? It's a legal fiction, and it sounds silly, but it can make the difference in whether a claim gets tossed or not. Okay? So incorporate that into your practice. Those of you who are planning on drafting lots of complaints, trust me, you never know what you're going to do. It's also why people hate lawyers. Inserting unnecessary, seemingly unnecessary legalese like that and things. You're getting your case tossed out because you didn't have that in there. Pretty annoying. Okay. This is just what I've been talking about. All those pieces of the complaint we looked at before, they're not necessarily required, but you get to make an impression on the defendant, the defense counsel, and the court. So don't just slop down whatever, even if you think you can get by that judge. Okay? Your reputation is the only thing you get to control. So go and look at other complaints before you draft your order. Okay? See what standard practice looks like. See what good practice looks like. Look at pleadings that have been drafted by practitioners that you feel like know what they're doing. This is a good rule of thumb for just about anything. Because not only is your reputation at stake, but you never know when the court is just going to have it in for you. And is going to want to toss your complaint out, okay? As we see in Kickball. Very quickly, nutshell, layperson synopsis. What happens in Kickball? Who has not read Iqbal? Liars. What happens? Go ahead.
Okay, so Iqbal was arrested and detained after the September 11th event as basically a person of interest, or high interest, and they locked him down in a harsh facility. And he's sitting basically saying that he was targeted because of his race and his religion. And he's saying that Mueller and Ashcroft, the Attorney General and the FBI director, were the cause of this.
The Robert Mueller is the Robert Mueller. Imagine him doing such a thing. So yeah, that's right. And what does the court say is wrong with the plaintiff's complaint? Let's see if we can motor this way.
He sort of like didn't say that they directly was the cause of him being detained. It was kind of like I'm trying to figure out the word for it. It was kind of an assumption. Like one of the courts assumed that happened and had no factual, no facts to back it up.
That's right. Yeah. So what does the trial court say? What was the standard that was used by the trial court in this case? How does the trial court do that? The trial court does what to the complaint? Trial court thumbs up or trial court thumbs down? Thumbs up, yes. Okay. Trial court does it. All right, go back and read it all again. Go back and read it all again. We're going to pick that up next week because this is a super important case, right? Really important. Really important. Especially if you're going to have a plaintiff's practice. Because this has now changed everything. This wasn't the case when I was here. Okay? This has changed everything for everybody. So if you read it all and you're like, yeah, okay, that's fine, okay. I'll read it again. Okay? Read it again. It's important. Let's jump ahead to our example scenario. We'll do the dog vision next time. Example scenario. Here it is. I want you to fill out that civil cover sheet that we looked at just a few minutes ago in class based upon this scenario. Okay? Can you do it in 10 minutes? Or less than 10 minutes? 8 minutes? If not, you live here. Pull up that civil cover sheet. It's very simple. It's easier than you think it is. Fill it in based upon this scenario. everybody see it okay? When you make the text bigger for Friday?
Yes, bigger.
Make it bigger. I don't know if I can do it now. Oh, there's way. Yes. Yes. And I have to conveniently situated off Sally Street. An hour and a half, 2 hours from now. So, okay.
Are we good? Are you?
You are the plaintiff's attorney. I thought I'm sorry. I have a different graph list that I didn't say, sorry. So yeah, you represent the court. I think there's something else now. If you didn't represent the plaintiff, you will not be filling out some questions. So we're in plaintiff world this week. Next week will be the defendant world. I feel like you got it up to the point of an educated guess and brings it. Where's Marlon? What?
You got a Graham Shop case here too.
It's coming tomorrow.
Yeah.
It's just have your point versus have How are you all doing?
Tired.
Yeah? Where's Marlon? Where's Marlon? What?
You got a Graham Shop case here too.
It's coming tomorrow.
Yeah.
It's just have your point versus have How are you? How are you all doing? How are you all doing?
Tired.
Yeah, but you.